Organized crime represents a steadily growing threat to modern societies, far surpassing the scale and impact of earlier forms of criminal cooperation. Today's criminal organizations operate with a level of coordination, efficiency, and adaptability that has never been seen before in history. Unlike isolated individual crimes, organized crime relies on multiple offenders acting together, which significantly increases both their operational power and their chances of success. The presence of accomplices not only strengthens the logistical and financial aspects of their activities, but also provides members with a strong sense of security and determination. This collective structure creates loyalty and fear at the same time, making it extremely difficult for members to leave or testify against the organization. Scholars and practitioners have long debated the definition of organized crime, yet no single formulation has been able to fully capture its complexity. The main difficulty lies in the fact that organized crime continuously changes its forms, depending on regions, cultures, and historical contexts, adapting quickly to new challenges and opportunities. In this part, we will discuss the legal definitions of organized crimes. To properly address organized crime, legal systems require clear criteria that distinguish it from individual criminal acts and highlight its collective, structured nature. For this reason, legal frameworks increasingly criminalize not only the completed offenses themselves, but also participation in or contributions to an organized criminal group. These provisions aim to strike at the roots of organized crime by holding individuals liable even before a specific criminal act is carried out. The approach allows authorities to intervene at an early stage, reducing the chances of criminal enterprises expanding their reach and influence. The laws of this kind recognize that organized crime is not simply about isolated offenses, but about continuous coordinated efforts to engage in serious criminal activity. By focusing on networks and collective operations, whether involving illicit goods, services, or infiltration of business and government, legal systems aim to disrupt organized crime before it consolidates further power. Let us look at the first legal concept: conspiracy. Conspiracy and criminal association are two key legal approaches developed to address the problem of organized crime. Conspiracy refers to an agreement between two or more individuals to commit a crime, even if the crime itself has not yet been carried out. This model is most common in countries with common law traditions, such as the United States, Canada, and Pakistan, where the focus is on penalizing the agreement itself. Criminal association, by contrast, is a broader offense that criminalizes participation in the activities of an organized criminal group, even if no specific offense is planned or executed. This approach is typical of civil law countries like France, Germany, and Italy, which emphasize dismantling criminal organizations rather than simply punishing completed crimes. Some jurisdictions, such as the United Kingdom, incorporate both models, providing prosecutors with greater flexibility when tackling organized crime cases. These legal frameworks demonstrate how different traditions seek to intervene at an early stage in order to weaken or disrupt criminal networks. Despite their differences, both approaches ultimately share the same goal: to prevent organized crime from growing and to shield society from its harmful influence. Why it matters: understanding the distinction between conspiracy and criminal association is crucial for recognizing how legal systems adapt to the challenges of organized crime. By focusing either on agreements or on ongoing group activity, These models give states tools to disrupt criminal networks before they cause further harm. Conspiracy laws allow legal systems to act proactively by criminalizing agreements to commit crimes, even before any offense has been attempted or completed. In some jurisdictions, the mere agreement itself creates criminal liability, while others require an additional act that furthers the plan. This proactive framework enables law enforcement to intervene at an early stage, stopping criminal enterprises before they can fully develop. Conspiracy provisions also make it possible to prosecute multiple individuals involved in organizing or planning crimes, even if they do not personally carry out the offense. By focusing on agreements, conspiracy laws hold not only the direct perpetrators, but also the masterminds and organizers accountable. This makes conspiracy an inchoate crime, meaning it punishes steps toward an unlawful act rather than waiting for the act to be completed. In organized crime cases, conspiracy charges are especially effective because they allow authorities to dismantle networks and disrupt operations before they inflict greater harm. Through the criminalization of collaborative planning, conspiracy laws strengthen the legal system's ability to attack organized crime at its very roots. Conspiracy laws highlight the importance of prevention in criminal justice. By punishing the agreement to commit crimes, they shift the focus from reacting to completed offenses toward disrupting criminal organizations before they achieve their goals. For conspiracy to exist, there must be an agreement between at least two individuals, as no person can legally conspire alone. While communication between conspirators is necessary to form the agreement, it is not required that all members know each other personally. What matters most is that each participant demonstrates commitment to the shared objective, regardless of the degree of their involvement. Some conspirators may take active steps toward carrying out the crime, while others may remain in the background as part of the plan without direct action. This flexible structure allows conspiracy laws to target both masterminds who design the scheme and lower-level participants who support it. It also ensures that individuals contributing indirectly to criminal enterprises can still be held legally responsible. By focusing on the agreement itself rather than completed acts, conspiracy laws provide a strong mechanism for disrupting organized crime before it escalates. Preventive capacity makes conspiracy an especially effective legal tool in dismantling networks at multiple levels of participation. Conspiracy law recognizes that organized crime is built on cooperation. By holding all committed participants accountable, regardless of their rank or direct actions, the law undermines the group's cohesion and prevents criminal plans from advancing to execution. Now focusing on one of the most important legal elements here. Purpose of the conspiracy agreement. The United Nations Convention Against Transnational Organized Crime expands the traditional understanding of conspiracy by connecting the criminal agreement to a specific purpose, obtaining a financial or other material benefit. This reflects one of the defining characteristics of organized crime. Organized criminal groups usually act for profit, economic advantage, or some other material gain, rather than for purely personal or incidental reasons. To understand conspiracy as a criminal offense, it is useful to distinguish between two fundamental elements of criminal liability: actus reus and mens rea. First, actus reus refers to the external or physical element of the offense. In the context of conspiracy, the central act is the formation of an agreement between at least two people to commit a criminal offense. Importantly, the planned crime does not necessarily have to be completed. In many legal systems, criminal liability may arise as soon as the unlawful agreement has been formed. For example, Imagine that two individuals agree to smuggle illegal drugs across an international border. Even if the drugs have not yet been purchased or transported, the agreement itself may constitute the actus reus of conspiracy. Similarly, if several members of an organized criminal group agree to establish a fraudulent company in order to deceive investors, the conspiracy may already exist before the fraud is actually carried out. The second essential element is mens rea, which refers to the mental or subjective element of the offense. The participants must knowingly and intentionally take part in the criminal agreement. In other words, they must understand the criminal nature of the plan and willingly agree to participate in it. Consider two contrasting examples. If a person agrees to transport a sealed package without knowing that it contains illegal drugs, that person may lack the necessary mens rea for conspiracy to commit drug trafficking. However, if a person agrees to transfer and conceal money while knowing that the money represents the proceeds of criminal activity, the required criminal intent is much easier to establish. The precise legal definition of conspiracy differs from one jurisdiction to another. Some legal systems require an additional step, sometimes called an overt act, to be taken in furtherance of the agreement. Other systems place greater emphasis on the agreement itself. Nevertheless, the distinction between actus reus and mens rea remains fundamental. There must normally be both a criminal agreement. The Organized Crime Convention adds another important dimension. The agreement must generally be connected with the purpose of obtaining, directly or indirectly, a financial or other material benefit. This requirement helps distinguish organized criminal activity from agreements that may technically involve unlawful conduct, but do not have the profit-oriented character typically associated with organized crime. Why is this important? The law of conspiracy allows criminal justice authorities to intervene before the planned offense is actually completed. Authorities do not always have to wait until drugs are trafficked, money is laundered, or victims are defrauded. If the necessary criminal agreement and intent can be proved, intervention may be possible at an earlier stage. This gives conspiracy law an important preventive function. By criminalizing profit-motivated agreements, the Convention enables authorities to disrupt organized criminal groups while their plans are still being prepared. Instead of responding only to completed crimes, the law can target the cooperation, coordination, and common criminal purpose that form the foundations of organized criminal enterprises. The key idea to remember is therefore simple. Conspiracy focuses on the agreement itself. The actus reus is the criminal agreement. The mens rea is the knowing and intentional participation in that agreement. And under the Organized Crime Convention, the agreement is closely connected to the pursuit of financial or material gain. To establish criminal liability for conspiracy, two fundamental elements must normally be considered together. Actus reus, meaning the external or physical element of the offense, and mens rea, meaning the required criminal intent. The table illustrates how these two elements work together. Let us begin with actus reus. In conspiracy cases, the central physical element is the formation of an agreement between at least two individuals to commit a criminal offense. The important point is that the planned offense does not necessarily have to be completed. Criminal liability may arise at a much earlier stage. For example, suppose two individuals agree to transport illegal drugs across an international border. Even if they have not yet obtained the drugs or begun the journey, the agreement itself may already satisfy the actus reus requirement. However, legal systems do not all define this element in exactly the same way. In some jurisdictions, the agreement itself is sufficient. Once the parties reach a genuine criminal agreement, the offense of conspiracy is complete. Other jurisdictions require something more. They may demand an additional step, often referred to as an overt act, which demonstrates that the conspirators have begun to put their criminal plan into effect. An overt act does not necessarily have to be criminal in itself. For instance, if two people agree to commit a bank robbery, purchasing equipment, renting a vehicle, or examining the location of the bank may provide evidence that the conspiracy has moved beyond mere discussion. The second element is mens rea, the mental element of conspiracy. Each conspirator must knowingly and voluntarily participate in the criminal agreement. The person must generally understand the unlawful nature of the plan and intentionally associate themselves with its criminal purpose. This requirement is particularly important because simply being present during a discussion, knowing someone involved in criminal activity, or accidentally assisting a criminal organization does not automatically make a person a conspirator. Consider an example. A driver may agree to transport several boxes for another person without knowing that the boxes contain illegal drugs. Although the driver's actions may objectively assist the criminal plan, the required mens rea may be absent because the driver did not knowingly join the conspiracy. By contrast, if the driver knows that the boxes contain drugs and deliberately agrees to transport them as part of the trafficking operation, both the external and mental elements may be established. The relationship between actus reus and mens rea is therefore essential. Actus reus asks, what did the participants agree to do? Mens rea asks, did they knowingly and intentionally join that criminal agreement? Both questions are important because conspiracy law is not designed to punish innocent association or accidental involvement. It targets deliberate cooperation between individuals who share a criminal objective. Legal systems differ in the exact balance they strike between these two elements. Some place greater emphasis on the agreement itself, while others require evidence that concrete steps were taken toward carrying out the planned offense. Nevertheless, the fundamental structure remains similar. There must be both a criminal agreement and the necessary criminal intent. This combination gives conspiracy law an important preventive function. Authorities do not necessarily have to wait until the planned crime has been completed. If investigators can establish the existence of a criminal agreement and demonstrate that the participants knowingly and intentionally joined it, intervention may be possible while the criminal activity is still in its preparatory stages. This is particularly important in the context of organized crime. Criminal organizations depend on cooperation, planning, division of responsibilities, and shared criminal objective. Conspiracy provisions allow the legal system to target these relationships before the organization successfully carries out its ultimate criminal purpose. The key point to remember is therefore straightforward. Actus reus represents the criminal agreement. Mens rea represents the knowing and intentional decision to participate in that agreement. Taken together, these two elements allow conspiracy law to address both the formation of criminal networks and the criminal intention that drives them. This makes conspiracy an important preventive tool in the fight against organized crime. Under the Organized Crime Convention, conspiracy is based on a voluntary agreement between at least two people to commit a serious criminal offense. The agreement must be genuine, intentional, and directed toward a shared criminal objective. This means that criminal liability may arise at a very early stage. The planned offense does not necessarily have to be completed, and in some legal systems it does not even have to be attempted. Once two or more individuals deliberately agree to participate in serious criminal activity, the legal system may already treat that agreement as a criminal act. Organized crime rarely begins with the final offense itself. It usually starts with communication, coordination, division of roles, and preparation. Not every participant has to play an equally important role. A person may still be considered part of a conspiracy, even if their contribution is relatively limited. One person may organize the operation, another may provide transportation, another may obtain documents, and another may simply assist with logistics. What matters is whether the individual knowingly and voluntarily joins the criminal agreement. For example, imagine a group planning a large-scale fraud scheme. One participant may design the fraudulent documents. Another may create false online accounts, and a third may agree to transfer the proceeds. Even if one participant has only a minor role, that person may still become part of the conspiracy if they knowingly support the common criminal purpose. In many jurisdictions, however, an agreement alone is not always sufficient. The law may also require an additional step, commonly referred to as an overt act. An overt act is a concrete action taken by at least one conspirator in furtherance of the criminal plan. Its purpose is to demonstrate that the agreement has moved beyond mere discussion and has entered the stage of actual preparation. The overt act itself does not necessarily have to be illegal. For instance, if several people agree to commit a robbery, purchasing masks, renting a vehicle, or obtaining information about the target location may qualify as overt acts. If a group plans to traffic drugs, scouting a border crossing, or arranging transportation may demonstrate that the conspiracy is being put into practice. Similarly, in a fraud scheme, preparing false documents, opening bank accounts, or creating fictitious business records may serve the same function. The requirement of an overt act, therefore, creates an additional safeguard. It helps distinguish genuine criminal conspiracies from hypothetical conversations, vague intentions, or statements that were never seriously acted upon. At the same time, conspiracy law still allows intervention well before the ultimate offense is completed. This creates a balance between two important objectives. On the one hand, the law avoids waiting until serious harm has already occurred. On the other hand, where an overt act is required, it demands some evidence that the criminal agreement has progressed beyond words alone. This preventive function is particularly important in the context of organized crime. Organized criminal groups often depend on detailed preparation before any visible offense takes place. Participants may acquire equipment, arrange transportation, establish communication channels, prepare false identities, transfer funds, recruit new members, or collect information about potential targets. Conspiracy law allows authorities to intervene during these preparatory stages. The central idea is therefore that conspiracy combines agreement, criminal intent, and, in some legal systems, concrete preparatory action. A voluntary criminal agreement shows the shared purpose of the participants. The required mens rea demonstrates that they knowingly and intentionally joined the plan. An overt act, where required, shows that the criminal project has begun to move from planning toward execution. Why does this matter? Organized crime becomes more dangerous as criminal networks develop resources, coordination, and operational capacity. If the law required authorities to wait until the final offense was completed, opportunities for prevention would be severely limited. By imposing liability for criminal agreements and, where required, preparatory acts, conspiracy law makes it possible to disrupt criminal enterprises at an earlier stage. The key point to remember is this: conspiracy law is designed to target the formation and development of criminal cooperation before the planned serious crime is fully carried out. This early intervention approach makes conspiracy one of the most important preventive legal tools in the fight against organized criminal networks. Now moving on to the legal concept of criminal association. Different legal traditions have developed different mechanisms for dealing with organized crime at an early stage. In common law countries, one of the most important legal tools is the offense of conspiracy. Conspiracy focuses primarily on an agreement between two or more individuals to commit an unlawful act. The central concern is therefore the existence of a shared criminal plan. In civil law systems, by contrast, the preferred mechanism has traditionally been the offense of criminal association. Instead of concentrating mainly on an agreement to commit a particular offense, criminal association focuses on participation in a criminal group itself. This model is often associated with the French concept of association de malfaiteurs, which developed historically from French criminal law and became an important model for similar offenses in many civil law jurisdictions. The difference between the two approaches is significant. Under a conspiracy-based model, prosecutors generally have to establish that two or more people reached a criminal agreement. The agreement normally concerns the commission of one or more offenses, and the prosecution must demonstrate that the participants intentionally joined that common criminal purpose. For example, imagine that 3 people agree to organize a large-scale drug trafficking operation. One participant will obtain the drugs, another will arrange transportation, and a third will distribute the drugs after they arrive. Their agreement may form the basis of a conspiracy charge even before the trafficking operation is completed. The offense of criminal association is structured somewhat differently. Here, the central issue is whether an individual knowingly participates in an organized criminal group. Liability does not necessarily depend on proving a detailed agreement concerning a specific future offense. The emphasis is instead placed on the existence of the criminal organization and the individual's connection to it. For example, suppose a person deliberately joins a structured criminal group that regularly engages in fraud, extortion, and money laundering. Even if prosecutors cannot prove that this person participated in a particular discussion about a specific future crime, membership or active participation in the criminal association may itself create criminal liability. This makes criminal association particularly useful when dealing with complex criminal organizations. Large organized crime groups do not always operate through a single, clearly identifiable agreement. Members may have different responsibilities, may know only part of the organization's activities, and may participate in different criminal operations at different times. A criminal association offense allows the legal system to focus on the criminal structure itself rather than requiring proof of one specific conspiracy involving every participant. Conspiracy and criminal association are therefore based on somewhat different ideas. Conspiracy focuses primarily on the criminal agreement. Criminal association focuses primarily on participation in a criminal organization. Despite this distinction, both are generally treated as autonomous offenses. This means that they exist separately from the underlying crimes that members of the group may later commit. A person may therefore be prosecuted for conspiracy or participation in a criminal association, even if the planned robbery, trafficking operation, fraud, or other serious offense is never successfully completed. This autonomous character gives both offenses an important preventive function. Criminal justice authorities do not necessarily have to wait until victims have suffered harm, or until the criminal organization has successfully carried out its plans. Instead, the law can intervene while criminal cooperation is still being organized and developed. However, the evidentiary focus is different. In a conspiracy case, investigators may search for evidence of a criminal agreement. This could include communications between participants, planning meetings, messages, financial arrangements, or other evidence showing that individuals agreed to pursue a common criminal objective. In a criminal association case, investigators may focus more heavily on the structure and activities of the group. Evidence may concern membership, hierarchy, repeated cooperation, organizational roles, financial links, communication patterns, or participation in the continuing activities of the organization. These differences reflect broader characteristics of the two legal traditions. Common law systems have historically placed strong emphasis on the concept of agreement as the foundation of conspiracy liability. Civil law systems have often developed offenses that concentrate more directly on participation in structured criminal groups. Neither approach is necessarily superior in every situation. They represent different legal techniques for addressing the same fundamental problem: collective criminality. Organized crime is particularly difficult to combat because responsibility is often distributed among many participants. The person planning an operation may never personally commit the final offense. A financier may provide resources without being present at the scene. A transporter may carry out only one part of a much larger criminal operation. Both conspiracy and criminal association offenses allow the law to look beyond the final criminal act and examine the wider network of cooperation behind it. Why does this matter? Understanding the distinction between conspiracy and criminal association demonstrates how different legal traditions can pursue the same preventive objective through different legal concepts. Common law systems generally focus on the agreement to commit crime, while civil law systems may focus more directly on participation in the criminal group itself. Despite these differences, the underlying goal is similar: to prevent organized criminal groups from becoming stronger, more coordinated, and more capable of committing serious offenses. The key point to remember is therefore this: conspiracy targets criminal agreement, while criminal association targets participation in a criminal organization. Both mechanisms allow authorities to intervene before the criminal group's ultimate objectives have been fully achieved, making them important preventive tools in the fight against organized crime. Intention to participate in the criminal group and knowledge of its aim. This section focuses on the mental element of participation in an organized criminal group. We will examine what it means to intentionally take part in the group's activities and how far a person must understand the group's criminal purpose in order to incur criminal liability. Like conspiracy, criminal association laws vary across countries, but they share one central idea. Criminal liability is based on participation in a criminal group rather than on proof of a specific criminal agreement. To be held responsible, a person must intentionally take part in the group and must know, at least in general terms, about its criminal purpose. Liability may also arise when someone supports the group through activities that are not criminal by themselves. For example, a person who manages finances, operates a front business, or provides logistical support may still be criminally liable if they knowingly help the organization achieve its unlawful objective. This means that criminal association laws can reach not only those who directly commit offenses, but also those who help the criminal organization function and survive. Their main advantage is therefore preventive. Prosecutors can intervene before a specific offense is completed, targeting the structure and support network of the criminal group itself. The key point is simple. Intentional participation, combined with knowledge of the group's criminal purpose, can be enough to establish criminal liability. Like conspiracy, criminal association laws vary across countries, but they share one central idea. Criminal liability is based on participation in a criminal group rather than on proof of a specific criminal agreement. To be held responsible, a person must intentionally take part in the group and must know, at least in general terms, about its criminal purpose. Liability may also arise when someone supports the group through activities that are not criminal by themselves. For example, a person who manages finances, operates a front business, or provides logistical support may still be criminally liable if they knowingly help the organization achieve its unlawful objectives. This means that criminal association laws can reach not only those who directly commit offenses, but also those who help the criminal organization function and survive. Their main advantage is therefore preventive. Prosecutors can intervene before a specific offense is completed, targeting the structure and support network of the criminal group itself. The key point is simple. Intentional participation, combined with knowledge of the group's criminal purpose, can be enough to establish criminal liability. The table compares two main approaches to organized crime: criminal association in civil law systems and conspiracy in common law systems. Criminal association focuses on participation in a criminal group, while conspiracy is based on an agreement to commit a crime. In recent years, some countries have combined elements of both models to create more flexible legal frameworks. Many jurisdictions also limit these offenses to serious crimes, helping to avoid overly broad criminal liability. The overall trend is toward greater convergence between the two approaches, with the same basic objective: disrupting organized crime at an early stage. The next section examines how different states apply these models in practice.